I hope everyone was able to stay dry today. It rained like crazy. Just like always, I'm going to mute everybody, and you can unmute yourself if you have to ask a question. And we might as well get started because I think it's about 7 o'clock and it's Friday night. I know everybody's got better things to do than to listen to a class on deeds. So that's the class we're going to do tonight. The chapter is deeds. I think it starts on page 297. So just let me get my book open. Short chapter, only a couple of key words. Okay, so in New Jersey, we transfer real property by deeds. And the reason we transfer real property by deeds is we are an allodial state. And in an allodial state, we transfer real property by deeds, and we transfer personal property by bill of sale. So real property by deeds and personal property by bill of sale. So a deed, it's a written instrument that transfers an interest, right, or title in realty. And New Jersey has an allodial system of real estate, so we transfer real estate by deed. And we talked a little bit about it last night, that you can transfer an easement by deed, or a defeasible fee by deed, or a life estate by deed. The tool by which we transfer a right in real estate is a deed. There's different forms of transferring, different forms of changing owners. And when we change owners, we actually call it alienation. Changing owners is alienation. So there's different ways of alienating, different ways of transfer. First of all, there's intestate distribution. Intestate distribution is when you pass away and you have no will, and then your personal property and your real property is distributed by the law of descent. And if you look in the book at the chapter, at the end of the chapter on that process of transferring, you'll see that the law of descent, if you die without a will, your property might not go to where you want it to go. Also, if you die with a will, you're said to have died testate. And if you've died with a will and it's testate, then your property is transferred by your will, by whatever you've directed in your will. We also have forms of involuntary transfer or involuntary alienation. Those things that are involuntary alienation are things like condemnation, tax sales, public sales in order to satisfy judgments. People are coming in here. Let me let them in. And we also have voluntary alienation. Voluntary alienation is things like selling, like giving, like dedicating. Dedicating means that you have transferred the property to the state of New Jersey, and there has to be a voluntary acceptance by the state in order to take it. Those are all forms of voluntary alienation. Okay. We can also have alienation or changing ownership by deeds. And again, by deeds, when we talk about deeds, we can have different types of deeds that give us different types of end results and different types of risk-reward profiles. First one is a full warranty deed. A full warranty deed is the highest level of deed. And with a full warranty deed, the grantor, and that's the person who is in possession of the property now, the grantor makes promises. And those promises, if you look on page 297, they make promises or covenants. And so the covenants are the covenant of season, and that's an important one, the covenant of season. The covenant of season is where the grantor says that he is the owner of the property and that he has the right to transfer it. Season is a Latin word that means I am possessed of. The second thing in a full warranty deed is a covenant against encumbrances. That's where the grantor is promising that there is no encumbrances on the property except the ones that he has made you aware of. Now, what's an encumbrance? We have a chapter on encumbrances, but an encumbrance is a lease, a restriction, a easement, a license. Those are all types of encumbrances. And here's where the grantor is going to say whether there's any encumbrances against the property. Also, a type of encumbrance is a lien. So a lien is an encumbrance. The next promise the grantor makes is the promise of quiet enjoyment. The promise of quiet enjoyment is where the grantor says that whatever happens from now till the end of time, if somebody tries to come up and say that they are the rightful owner of the property, they exert a claim of priority, that's called, that the grantor will do whatever he can do to not have the ownership taken away from the grantee. That's quiet enjoyment. Also, we have the covenant of further assurance. In the covenant of further assurance, the grantor promises to perform any reasonable act necessary to make the title good sometime in the future. And, an example might be the legal description is flawed, and then the grantor must correct it. And then the next one is the covenant of warranty forever. This is where the grantor promises to pay for the defense of the grantee's title if it's challenged by a third party. So what these covenants are doing is they are saying to the grantee, if you buy the property from me, if you, the grantee, buy the property from me, I, the grantor, will promise you all defenses against somebody taking ownership away from now until the end of time. And that's a very, very high degree of risk for a grantor to take. So we typically don't use the full warranty deed. It's really too risky for the grantor. Remember, the grantor is the person who has the deed now and who's transferring ownership to the grantee. So we typically do not use warranty deeds or full warranty deeds in New Jersey. Instead, we use a bargain and sale deed with covenants against grantor's acts. Now, if we go back again and we're talking about risk, a warranty deed offers protection from the beginning of time to the end of time. And that could be a really long period of time. And so in a full warranty deed, the risk in a full warranty deed, the risk is all being assumed by the grantor. The grantor has the highest degree of risk. And the grantor may not really want to take that highest degree of risk. So what we use as kind of a compromise in New Jersey is we use a bargain and sale deed with covenants against grantor's acts. And a bargain and sale deed with covenants against grantor's acts has a covenant of season. So just like the full warranty deed, the covenant of season says that the grantor is fully possessed of the rights to the property and has the ability to transfer them. And now if we look again at our seesaw teeter-totter, we kind of see that the risks are more balanced out than they were before with a full warranty deed. In other words, the grantor is not taking excessive risks by making promises from the beginning of time to the end of time. In a bargain and sale with covenants against grantor's acts, that's typically the kind of deed that we use in real estate every day when we're transferring ownership. That's known as a special warranty deed. And that special warranty deed, the aspect of it that makes the risk kind of even is the grantor only makes promises about what he did during his period of ownership, because he's making promises against grantor's acts. He's telling you what he did, covenants against grantor's acts during his period of ownership only. So he's saying from here to here, I'm telling you what I did to encumber the property. All right, and that's the kind of deed that we use every day in real estate. And it's accepted that that kind of a deed coupled with title insurance, gives us evidence of marketable title. So the bargain and sale deed is the next kind of a deed, and that changes the risk to even more evenly balanced out, where the risk between the grantor and the grantee are much more evened out. A bargain and sale deed does have a covenant of season. So we've seen that all three deeds, bargain and sale deed, full warranty deed, right, has a covenant of season, A bargain and sale with covenants against grantors acts does have a covenant of season, and a plain old-fashioned bargain and sale deed does have a covenant of season. Again, that covenant of season is where the grantor says, I am possessed of the property and have the right to grant, have the right to transfer ownership. That's the covenant of season. Now, in a bargain and sale deed, you notice we don't have that with covenants against grantors acts. So in a bargain and sale deed, the grantor is saying, I am the owner, and I have possession, and I have the rights associated with the real property, and whatever I have is what you're getting. So it's kind of an as is. It's kind of an as is. You're going to get the deed, whatever I have, you get. But I'm not taking or not making any promises against the acts I had while I was in ownership, because that would be a covenant of season, a bargain and sale with covenants against grantors acts deed in that case. And here, our risk to our grantee is greater, because here what we're saying is, here's the deal. I'm going to sell you this property, and whatever encumbrance it has, you're going to be stuck with those encumbrances. It's kind of like buying a car as is. When you buy a car as is, and they say, listen, I'm selling you this car as is, whatever's wrong with it, you're stuck with. All right, so this is a bargain and sale deed. So again, the most protection for a grantee is a full warranty deed, where we kind of even out the risk between the grantor and the grantee is a bargain and sale with covenants against grantors acts deed. And that, coupled with title insurance, gives us marketable title. And now where the risk is greater to the grantee, because the grantee is getting just what the grantor is giving him, the grantor is not making any promises, a bargain and sale deed. So a bargain and sale deed is what the grantor has, the grantee is getting without any covenants of season. Those are the first three kinds of deeds. And remember, all three of them have a covenant of season. And then we do have one other kind of a deed, and that's a quitclaim deed. And you can see on the teeter-totter, on the quitclaim deed, that grantee is taking all the risk. The grantee has the most risk. The most risk is on the grantee. And you can see the grantee is right down on the ground here. The grantee has the most risk. Because what a quitclaim deed does is, you notice there is no covenant of season. There is no covenant of season. So in a quitclaim deed, the grantor is not even saying that he is the owner of the property. What a quitclaim deed does is the grantor says, I'm not saying I'm the owner of the property, but I will never make a claim of ownership against the property. So there's no risk or obligation to the grantor. The grantor is saying, I'm not even saying I'm the owner. Notice there's no covenant of season. I'm not even saying I'm the owner, but I'm promising you I'll never make a claim against the property. Now, when is this used? Well, in my case, when I was married to my first wife, we had 18 properties in New Brunswick. And some of the properties I bought myself during the time we were married. Under my name, they weren't principal residences, they weren't part of community property, and I bought them by myself while we were married. After we were divorced, so our divorce was in 1998, after our divorce, if I wanted to sell that property, the title insurance company for the buyer wanted to make sure it had never been a marital residence, because if it was a marital residence, my ex-wife would have had a dower right. And so how can we be sure she doesn't have a dower right? Well, the only way they could be sure was to go to my ex-wife and ask her to sign a quitclaim deed. In that quitclaim deed, she would say, I have no ownership, but I promise I will never bring a claim against the property. So in a quitclaim deed, the grantor is not taking any risk, because he's not even saying he's the owner. So there's no risk at all to the grantor. The grantee is potentially taking a risk, because the grantee could be getting nothing. If I gave a quitclaim deed on a house that you own, and I gave a quitclaim deed on that house to someone else, Well, the person who was getting that deed from me would be taking the most risk because that quitclaim deed might not have any value at all because there's no covenant of season. I don't own your house. I don't have the right to say I am possessed of your house. Therefore, it would have no covenant of season, and therefore, it may not convey anything to the grantee. So the quitclaim deed is just used, for the grantor to promise he will never bring a claim against the property. All right, now those are the four main types of deeds. And the question that's always going to come up on the test is which one of the four types of deeds does not have a covenant of season? And the answer to that is the quitclaim deed. The quitclaim does not have a covenant of season. Now, we also have deeds for special occasions. Because not every deed fits into these four different types of deeds. Not every deed fits into a warranty deed, a bargain and sale with covenants against grantors acts deed, a bargain and sale deed, or a quitclaim deed. And we'll find out in a minute why some deeds don't fit into those. Well, first we have an administrator's deed. When do you have an administrator? You have an administrator when somebody has died without a will. And so when someone has died without a will, an administrator is appointed by the probate court, and then the administrator has the ability to sell off that real estate. And that administrator then would use an administrator's deed to transfer ownership. The next is a deed of correction. A deed of correction is a deed where if there's a mistake on the deed, like the spelling or the legal description, and remember on a deed, the legal description is always a meets and bounds description, or an incorrect name, that is corrected with a correction deed. The next one is a deed of trust. And again, we are in a lien theory state as far as transferring ownership of real property. In a state that does deeds of trust, a deed of trust is that deed where the grantor gives the deed to a trustee, and then the trustee holds it until the grantee makes all the payments. And when the grantee finally finishes paying it off after 30 years, the deed is delivered to him. If he doesn't make payments, then the deed is delivered back to whoever lent the money or whoever is the trustor. So again, that's a deed of trust. Different kind of deed. The next kind of a deed is an executor's deed. An executor's deed is used when you die and you have a will. When you die and you have a will, an executor is appointed, and that executor then delivers an executor's deed. Okay? The next kind of a deed is a gift deed. So one of the essential elements of a deed, is recital of consideration. Recital of consideration. And what recital of consideration means is how much, what of value, how much money, what you're trading for, what is the thing of value that's supporting the transfer? What is the consideration? What are you paying for? Now, in a gift deed, when you're giving somebody a house, there's no money changing hands. What's changing hands is love and affection. Sue, you came in at exactly the right turn. Love and affection is what happens when you are just changing hands without any money. So that's a gift deed. The next kind of a deed is a guardian's deed. Another essential element of a deed is you have to be 18, sane, and sober. So when Justin Bieber bought his house in Canada and then went to sell it, he was still 17. And he couldn't sell it because he wasn't a competent party. He wasn't 18 yet. And so then there was a court case as to whether or not Justin Bieber's father would be the guardian or his mother. So that's a guardian's deed. If your grantor is not a competent party. By the way, if we follow that story, Justin Bieber bought a house when he was 17. So you can be a grantee when you're 17. You can get a house when you're 17. You just can't sell it. In order for you to sell it when you're 17, you have to have a guardian. The next kind of a deed is a sheriff's deed. A sheriff's deed is the deed that you get when you buy something at the sheriff's sale. And when we're talking about these deeds, remember, in a sheriff's deed, in a guardian's deed, an executor's deed, and an administrator's deed, it's obvious that we can't use the bargain and sale with covenants against grantors' acts. We can't use that kind of a deed because none of these can make the promises because they weren't the owner of it for that whole time, right? In a bargain and sale with covenants against grantors' acts, remember the grantor only promises to tell you what he did during his period of ownership. So these deeds are for, this is for a dead person. The dead person can't promise what he did during this period of ownership. This is a dead person. They can't promise what they did during this period of ownership. This is a guardian, so you can't expect a 17-year-old to be able to actually give you, let's say, meaningful and legal testimony about what he did during his ownership. And in the sheriff's deed, the sheriff is not the one who owned it during this period. It's the person who lost their house. So all of these deeds are there because we can't use a bargain and sale with covenants against grantors' acts deed. All right, Justin Bieber, this is his house he bought in Canada when he was 17. When he went to sell the house, he needed to have a guardian appointed. And again, it created a court fight between his mother and his father. You get a sheriff's deed at the sheriff's sale. Here's a list of the sheriff's sales as they were on 6/3/2020. They are still not having sheriff's sales yet because of the coronavirus. But if you were to buy one of these properties from the sheriff's sale, you would be delivered with a sheriff's deed. The essential elements of a deed is it must be a written instrument. So a deed is a written instrument. A deed is a written instrument. It does not have to have a date. It does not have to have a date. It's a good idea to have a date, but it does not have to have a date. It has to have the legal capacity of the grantor. So the grantor has to be 18, sane, and sober. It has to have a named grantee. So in the deed, you have to name who is the grantee, and that person you're naming could be a fictitious person. So for instance, John Wayne's name was Marion Barber. So when John Wayne would own property, he wouldn't own it in the name of Marion Barber. He would own it in the name of John Wayne, but that was a fictitious name. But it was allowed because that sufficiently identified John Wayne as who he really was. There also needs to be recital of consideration in a deed. And we talked about in a gift deed, the recital of consideration is for love and affection. So we have to have a recital of consideration. In most deeds, there's something changing hands. $200,000, $400,000. I'm trading you your house for my house in a 1031 exchange. So some recital of consideration. And there needs to be words of conveyance. There needs to be some verb that indicates your intention to transfer. And the verb could be I sell, I give, I grant, some verb that indicates your desire to change that real property interest right. And then it also needs to have a habendum clause. Habendum clause comes from the Latin word to have. If you watch cop shows on TV, you'll notice that they always say, I'm going to file a writ of habeas corpus. Habeas corpus means, where do you have the body? Because if you're holding somebody without charging them, their lawyer can ask to have them released via a habeas corpus petition. So this habendum means the same thing. How much of an estate do you have? Habeas corpus on cop shows means, where do you have the body? Habendum means, how much of an estate do you have? Do you have a life estate? Do you have a defeasible fee estate? Or do you have a fee simple estate? That's where we spell out what kind of an estate we have in the habendum clause. One of the questions on the test always seems to be, where do we find a habendum clause? And we find a habendum clause on a deed. A deed also has to have a legal description. In New Jersey, when you're transferring ownership by deed, the deed has to be accompanied by a meets and bounds definition. Remember, meets and bounds is beginning at a point and heading, we always go clockwise, by the way, beginning at a point, and then we're going to head west 50 feet, and then we're going to head south 100 feet, then we're going to head east 100 feet, then we're going to head north 100 feet, and that kind of outlines where our property is. That's a meets and bounds definition. And in New Jersey, on deeds, they have to be accompanied with a legal description, and a legal description is a meets and bounds description. Any exceptions or reservations you're going to put in the deed have to be included. So, for instance, if you're going to reserve the right to not allow any fences on the property, that would be where you'd put in the reservations. Any warranties and covenants, right? If you have a full warranty deed, you have all those warranties and covenants. If you have a bargain and sale with covenants against grantor's acts deed, you still have a covenant of season, and you have several other covenants. And then, very important, it is the grantor who signs a deed. One of the test questions will be, who signs a deed? And it's the grantor who signs the deed. Then in order to have the deed work for transferring ownership, there has to be delivery and acceptance in the here and now. Delivery and acceptance in the here and now. Now, think about it. We have to have delivery and acceptance in the here and now. That's why we don't need a date. That's why we don't need a date, because if you're having delivery and acceptance in the here and now, we both know when it happened. So again, we have to have delivery and acceptance in the here and now. And then the deed should be recorded to protect the grantee. And in order to record the deed, it has to be accompanied with an acknowledgement. And that acknowledgement is acknowledging the grantor's signature. That's how they know that the grantor signed it. Because, you know, it'd be easy to forge a deed and just sign somebody's signature. But how does the county clerk know that you didn't forge it, that it really was the grantor who signed the deed? They look at the acknowledgement. And the acknowledgement is a swearing. For instance, if I was going to sign a deed, I would swear that I was Bruce Parker, and then an officer of the court, that would be an attorney, notary public, or the county clerk, would say, Bruce has sufficiently identified himself to me that I'm sure it's him. And then when that acknowledgement is accompanied the deed, it can be recorded. And the deed is recorded to protect the grantee. The deed is recorded to protect the grantee. And why are you recording the deed to protect the grantee? Because if there's a grantor, and he's a crook, and he's going to come to you and he's going to say to you, I want to give you a deed on this property. I'm selling you a house, and I'm going to give you a deed on the property. But do me a favor and don't record it. And then he's got someone else down here, and he's going to prepare a new deed, because all you're doing is typing up a piece of paper. He's going to prepare a new deed and give it to him. Then he's going to run to the county clerk's office in Freehold, and he's going to record it. He would now have the better claim. Even though you gave the deed to him first, now you created a second one and gave it to him. He runs it and records it first, he has the better claim. This guy should have recorded it. It protects him to quickly go and record the deed so that this can't happen. Therefore, it is the grantee who pays to record the deed. It's the grantee who pays to record the deed. When we transfer real property, we have to pay Realty Transfer Tax. In New Jersey, the Realty Transfer Tax is usually paid by the seller, except that there is a $1 million tax. For any sale that's over $1 million, there is a 1% tax. And that is not necessarily paid for by the seller. That's always a negotiation, whether the buyer or the seller is going to pay it. So think about it. If you sell a house for $1 million, there's going to be a 1% tax. So 1% of $1 million. So 10% of $1 million is 100,000. 1% of $1 million is $10,000. It'll be a $10,000 tax that somebody has to pay. And think about it, if you sold the house for $999,999, there's no $10,000 tax. So if you just sell it for $1 less, you save $10,000 in taxes. So again, always be aware if you're selling $1 million homes that $1 million tax is going to kick in at 1%. You should go $1 million or above. And again, the realty transfer tax is usually paid for by the seller. The realty transfer tax rates have a sliding scale. The less expensive the house, the lower the percentage rate as you go up in values on the house. If you go up in price, then the amount that they collect is a higher percentage, and it can be relatively expensive, the realty transfer tax. All real estate transactions have to be reported to the IRS, and they have to be reported to the IRS so that the IRS knows if there is a capital gains event. There's a form that accompanies all closings, and that form is, what are the proceeds? And that proceeds then is, that form is filed with the IRS, and the responsibility of filing it falls on first, the mortgage lender, second, the seller's broker, third, the buyer's broker, and fourth, anyone else who knows about the transaction. So if nobody tells the IRS, then all these people can be in trouble for not telling the IRS that there was a transaction. And the reason the IRS wants to know there's a transaction is because that transaction might have created a capital gains event. And the IRS likes to get paid its taxes. All right, so let's go over a couple of questions. And again, because I rushed everybody last night, and I got one of the questions wrong last night, by the way, it was the last question. The last question last night, the answer should have been tenants in common. We knew that. We knew it should have been tenants in common. But since I was rushing, I agreed with somebody who said it should be joint tenants with rights of survivorship. But the last